Good morning, everyone, and welcome to the Law Research Centre of Dublin City University. My name is Federico Fabbrini. I am a full professor of law at DCU, the director of the Law Research Centre, as well as the founding director of the Brexit Institute. And it is my great pleasure to open this event entitled Regulating Artificial Intelligence, Ireland, the United Kingdom, and the European Union. This is also an event which gives us the opportunity to announce the publication of a recent book entitled Data Protection and Digital Sovereignty Post-Brexit, which is edited by my colleague Edoardo Celeste, together with Edina Harbinja, Rosin Costello, and Napoleon Xantoulis, published by Hart Publishing in Oxford and released only a few months ago. I would like to begin this meeting by thanking warmly Arthur Cox for sponsoring the work of the DCU Law Research Centre. And I'm very grateful that Colin Rooney has joined us today. Moreover, I would like to welcome to Dublin City University Edina Harbinja and Lilian Mitrou and thank them for joining us in this meeting. And finally, last but not least, I want to warmly thank my colleague, Edoardo Celeste, who is also the Deputy Director of the Law Research Centre, for putting together this initiative. Needless to say, as many of you will know, the timing of this seminar could not have been more perfect because just yesterday, the European Parliament approved the AI Act, which is the first ever legislative framework for regulating artificial intelligence. And the law will enter into force in the coming months, once approved also by the Council of the European Union, most likely before the EU elections in June. To discuss this milestone, this major development, we have put together a stellar panel which will consider the consequences of the AI Act for Ireland and the European Union, as well as for the United Kingdom. So let me introduce our speakers in the same order in which they appear on the program. The first one to intervene will be Colin Rooney, who is a partner at Arthur Cox, one of the leading Irish law firms, where he leads the group on law, technology, and innovation. Colin, we are very grateful to have you back. Colin has spoken multiple times at DCU Law over the last few years, and we are delighted that he's joining us again. After Colin, I will pass on the floor to Edina Harbinja, who is reader in media and privacy law at Aston University in Birmingham in the United Kingdom. As I said, Edina is one of the co-editors of the book on data protection and digital sovereignty post-Brexit, and she has written extensively about also the Commission adequacy decision vis-a-vis the UK. Thirdly, I will call in Lilian Mitrou, who is professor of law at the Aegean University in Greece, on exactly the opposite side of our European Union, 2 time zones away from where we are, just to remind everyone of how big our union is. Lilian is an expert on artificial intelligence and has also contributed to the book, and we are very grateful to welcome her, I think, for the first time in the Law Research Centre. And then finally, last but not least, indeed, my colleague Edoardo Celeste, who is Associate Professor of Law, Innovation and Technology at DCU, will conclude this seminar by launching formally the book he co-edited and sharing his final reflection. Let me remind everyone that we are recording this event and that after the presentation at the end of the seminar, there will be a Q&A session, which I will be moderating. So feel free in due course to raise your virtual hand. We will unmute you, or alternatively, if your mic doesn't work, please send to me or to Charlie Halford, or project coordinator, your questions via chat. It's wonderful to see that we have up to 70 people participating to this event. It only confirms the importance of it, and I see many more coming in as I speak. But I'll stop here now and hand over immediately the floor to Colin for his initial remarks on AI and Ireland. Thank you very much, Colin.
Thank you very much, Federico, and thank you to DCU and to Edoardo and to all of the panel for the invitation today. It's a pleasure to be here, and it's a pleasure to speak to everybody. I was contemplating what to say about Ireland and AI last week and in more detail this week, and it struck me that I didn't want to overlap with what Lilian is going to talk to you about, and in particular the legislation. And as Federico has pointed out, the timing of this panel discussion is incredible in the sense of yesterday we had the European Parliament vote, and today we have the legislation. So in thinking about the role of Ireland, what I thought would be most useful or most beneficial, and hopefully it is beneficial to the group, is in the 10 minutes I have, is just to talk to you a little bit about some of the things that are coming across my desk in relation to AI. I act for, and Arthur Cox, we act for, as will a lot of the sort of large law firms in Ireland, we act for a range of different clients in the tech, pharma, construction, energy, food, retail, services, and we are seeing a range of different issues come up, and we're quite early, I think, in relation to organizations grappling with AI, and it's not just the AI Act that they're grappling with. There's a sort of a rapidly evolving, rapidly expanding regulatory framework in which organizations are now facing. And I thought it would be useful just to spend a little bit of time talking through what I see as being the environment in which businesses will be operating for the next maybe year, 2 years, in the context of a new AI Act, but a whole bunch of new EU digital laws and how these will all interact in relation to, or may interact in relation to, AI matters. So if you can bear with me for the next maybe I'd say this was 9 minutes, and hopefully that will be informative, as will be abundantly clear to you after, if not already abundantly clear to you after the next 9 minutes. I'm no academic. I'm very much a practitioner. My sort of hands are very much in the weeds. I'm very much on a day to day. So I'm trying to maybe bring that perspective. I can no way compete with the other two panelists in relation to their academic expertise, but just thought that might be a useful framework in terms of a useful kind of context to provide. I mean, I think there's definitely been a frenzy of activity. Sorry, I have a set of slides which I will just share briefly before we just jump back to, hopefully you can see, hopefully they're coming through reasonably clearly. I just launched that there. We go back up to the top here. So you'll be pleased to know I'm not going to go through the 15, 20 slides that I have here, but just as a guide, maybe in terms of some of the things that I'm going to talk about, I thought it'd be useful to have that as a backdrop. I mean, certainly there's been a frenzy of activity on the legal side, a frenzy of activity in terms of AI compliance, AI possibilities, since at least November 2022. And really in the first half of 23, we've had a lot of inquiries from organizations coming to us and saying, please help us understand what the rules are around AI, help us to understand what we might be facing into. Those inquiries kind of led me to understand there's actually quite a lot of general purpose AI in particular already in organizations. There's already kind of a lot of use of AI, far more than perhaps I would have anticipated before. So any kind of regulatory framework which is being introduced, and particularly a risk-based regulatory framework, is going to have an impact, but it's going to have an impact in relation to systems which are already in place within organizations. So I think a lot of the focus that we've had is preparing organizations in the context of procuring new solutions and the risk assessments and the due diligence and the kind of sort of governance that they will need to put in place to deal with these new coming, very exciting, very powerful systems. But there's a lot of it there already, and I think that that's a kind of a useful kind of thing to understand. And to be fair to the EU, and again, not to steal Lilian's thunder, because I think she's going to speak about this in some detail in her 10 minutes. The EU has been well ahead of the curve here, I think. The Commission in particular has, whether you agree with the what's in the AI Act or not, it has been moving the dial on AI regulation for some time, and in a very positive way, I think, over the last while. So yes, we've had an executive order come out of the US. Yes, we've had different sort of movements in different parts of the world. But again, when it comes to regulation in the digital space, the EU does lead the way. It is the sort of framework around which organizations and businesses and so the general commercial world tends to follow. So that may be just kind of a useful context to have. In terms of the practical issues around AI, and in particular the practical issues around using AI within your organization. I'm going to identify what I think are 4 topics which are worth consideration. And again, I've got one eye on the clock and making sure I don't overrun. The 4 issues that I think are certainly worth consideration and which we're going to see time and time again. And if you're working in a business context, you're going to face time and time again. I think are around, in no specific order, governance and oversight. That is going to be enormous. That is going to be an incredibly important part of introducing and operating AI within a business. Secondly, policies and documentation. And yes, there's a jaundiced view of policies to say, well, policies are often in place for the sake of having policies. My view on policies is policies exist so that organizations pursue a consistent approach in relation to AI. And that's going to be hugely important, particularly if there's a risk associated, if you're dealing with high risk AI per the new legislation. The policies that you have in place and the adherence to those policies in particular is going to be vital. Contracting, I think, is the thing probably that we're seeing most frequently now. So there is a document prepared by the European Commission, which I'm just going to try and probably won't come through with the fuzz I have on the screen. But there's this sort of very, very helpful piece of documentation: procurement of the AI community, the public buyers community guide, which the European Commission has published, which again is incredibly helpful in terms of trying to give a sense of the sort of things which you should expect to see being grappled with by your organization in the context of procuring and buying in a new IT solution. And there's a range of issues that come up, everything from defining the system to record keeping to transparency, or what I just prefer to describe it as explainability, and I'll come back to that in a moment, to human oversight, again, absolutely vitally important, to accuracy, robustness, security, and certainly then that's before you even get to sort of the interaction with the technical side of things, which is an incredibly important component of what we're going to see in relation to contracting and engaging in relation to AI solutions. But perhaps even more importantly, perhaps something just to think about is the initial due diligence and the initial risk assessment. So again, Lilian will probably touch on this in more detail, but we are dealing with a risk-based piece of legislation, and we have form in relation to grappling with and dealing with and understanding and working with risk-based legislation. And that's why I think there are a large number of parallels drawn or comparisons made between the AI legislation and the GDPR. Now, I've spent a lot of my career advising on GDPR, and in terms of my understanding of what I've seen in terms of the AI Act, I think these are fundamentally different things, aimed at fundamentally different sectors. Fundamentally, I mean, the definition in the AI solution is completely different, a completely separate thing to what you might see in relation to GDPR. And it's important that the two of them don't get confused. But there's a lot in the GDPR in relation to risk assessment. There's a lot in the GDPR in relation to assessments, particularly data protection impact assessments, that may tally with, and that can be, I think, useful in terms of understanding your requirements in relation to fundamental right impact assessments or conformity assessments or whatever other assessment that is that's potentially required in relation to the AI legislation. So I maybe just kind of put that there and say, don't just, there's a temptation to adopt two positions, which is to sort of run towards GDPR and say, wasn't that kind of very much what we're dealing with in an AI context? And I think that's not entirely correct. But there's also kind of a tendency to run away and say these things are entirely different. They've got no connection. They've got no interaction or interrelationship. And again, that's not entirely correct. There's much that we can learn from compliance with GDPR and the manner in which we have undertaken the risk assessments, whether that's around breach, whether that's around data subject rights, whether that's around the risks posed by a system, particularly around data privacy by design and privacy by default, which I think is transferable and which I think is useful in terms of the knowledge that you'll have to apply and the practices that you would have to apply in relation to AI. So conscious of time, I just wanted to kind of sum up by saying, I think we're in a space where there's a whole range of legal issues which are going to come to the fore here, not just in relation to the AI Act. And in many respects, the AI Act may be the most straightforward aspect of all. If you try to think about the interaction between, for example, the Data Act or the Data Governance Act and the AI legislation, or between the DMA and the DSA and the AI legislation, that before you even get to the interaction with that's telling me to stop, with the GDPR, that's telling you that there's a lot of us to grapple with here. And that's before, I haven't even had time really to deal with intellectual property issues, which are obviously vitally important and extremely potentially extremely risky in terms of engagement with an AI solution. So I've taken up enough of your time. I'm going to pause now, perhaps take some questions at the end as part of the panel discussion, but I just thought that would be a framework in terms of understanding how a practitioner at the coalface is sort of seeing this issue right now and grappling with the various different points which are being thrown up.
And thank you very much, Colin, for bringing in that practitioner perspective. That's exactly what we wanted in this seminar. That's also why we are so pleased that Arthur Cox has been engaging with us over the years, and I find those exchanges extremely fruitful. Let me now move on to Edina, who will instead take it from more of an academic perspective, but I think with a very sort of syncretic take as well. Edina, the floor is yours. I see you start sharing your slide.
Yes.
Maybe go back to one and put it on slideshow. Perfect.
Yes, yeah, definitely. Thank you. Glad you can see it. So I'll try and be short so that we allow for more time for Lilian, because I guess that's a bit more current and perhaps there is, of course, as we discussed earlier, a bit more detail. But what I entitled this talk is the AI regulation, or the lack of it in the UK. Well, the lack of it seems to be slightly improving. However, we'll see in what direction and what the main principles of this regulation in the UK seem to be. So I'll introduce some of the chronology, key documents and developments, and their key principles, and the ongoing debates and efforts by the government and other actors, the Parliament, of course, as well, in the UK, and offer some criticism to the extent that I can in this short.
Edina, the slides are not moving, though. Let me just point that out. I think we don't see the slideshow. It's still on slide 1.
Oh, okay. Yeah, sorry. Are they moving now?
No, but I think if you just try to click on second slide now.
I am on the second slide.
No, we still see the presentation. Exactly. Maybe if you don't put it on slideshow.
Can you see it like this?
Yeah, it's introduction now.
Okay, I'll keep it because in the slideshow then it seems not to be working. Sorry. It's okay. I don't have any notes that you're not supposed to see, so it's fine.
That's great. And then if you just move on, we will see on the left the prior. No, perfect. That's fine.
Okay, you can see. Okay, so great. Thank you. Thanks for the intervention. So the key documents that I've just sort of picked, the crucial ones. There are many other documents and analysis by the government and different departments, previously the DCMS and now the DCIT that leads this, the Department for Science, Innovation and Technology. Sort of the approach started with the National AI Strategy in 2021, developed further with the key principles in the AI policy paper in 2022, and then the main approach by the government has been sort of cemented in the white paper from March last year, pro-innovation approach to AI regulation, then opened the consultation period on this approach and the principles, and this consultation period ended, and we have just recently in February got government's response to the consultation responses that they've received, where they again elaborate on the approach and pretty much retain a similar approach. There's also an interesting piece of legislation or a bill in the Parliament at the moment that I also briefly touch upon in this talk. So the framework is, I've tried to summarize it here in the principle, in the approach, and as the Prime Minister said last year, the future of AI, safe AI. This may sound a little bit ironic when you're looking at it from a UK perspective and the approach that we're talking, but I've just put this as a provocation pretty much on this slide. So the focus of the whole approach has been for these 3-4 years on innovation and growth, flexible and adaptive approach that should differ from the EU's approach. And this approach has been also embraced in the data protection law reform that's ongoing with the Data Protection and Digital Information Bill and other pieces of legislation in the technology regulation area. So these principles based on cross-sectoral principles that we'll see shortly on the next slide, and a context-specific framework. So this is the core of the approach, meaning that the principles established in the framework should be implemented by different regulators in different sectors. They have been already implemented in certain sectors, as we will see shortly some examples of that implementation. So basically a very piecemeal approach, a sectoral approach that doesn't really have an overarching statutory framework proposed. International leadership and collaboration is also one of the principles, and voluntary measures on developers. So the key characteristics that the government has set out is that this is a pro-innovation, as I said, it should be proportionate regulation, trustworthy, adaptable, clear, and collaborative. So that's all sounds quite well. However, in the implementation and the coverage and some of the issues with this framework, it doesn't really translate to what is promised. So these 5 cross-sectoral principles that still have been retained since the white paper in the government response in February this year are the ones set out in. So safety, security, robustness, appropriate transparency and explainability, fairness, accountability and governance, contestability and redress. Well, nothing wrong with these principles, right? They have been established in other international documents, in OECD and others. They also, of course, permeate the EU's approach and many other regulatory approaches. However, the trouble is with the implementation of some of these, especially when we talk about the fairness, how that's implemented in the regulation of some of the problematic systems, also accountability and governance and the capability of the sectoral regulators that have sort of been put under the umbrella of the digital regulation forum, digital regulation cooperation forum, and the plan to introduce the statutory duty on regulators, all of these different sectoral regulators, including Ofcom, including the ICO, the data regulator, including the Consumer Markets Authority, etc., financial conduct, and many other authorities in various sectors, and requiring them to have due regard to the principles, which is interesting. And again, quite a, I would argue, vague and flexible approach that doesn't really promise strong safeguards for some of the problematic systems and uses. Further example that I mentioned is interesting is the AI regulation bill that has been introduced in the Parliament, in the House of Lords, last November by the Lord Holmes of Richmond. So it's a private members bill that is now in the second reading scheduled next week in the House of Lords. So we'll see what happens with this bill. It's interesting because it includes the 5 principles that I've just mentioned from the government's approach. It lists them explicitly and verbatim, and it also proposes to establish an AI authority that would oversee the regulation that is proposed. And amongst other things, it also proposes the introduction of the appointment of AI responsible officer within the regulated entities, and other requirements within the bill. So it's a very short bill that, in essence, implements government's principles, but also develops some of the oversight and introduces the AI responsible officer. As I said, we'll see what happens with it. It's a private members bill. These bills in the past have been adopted by the Parliament, the Computer Misuse Act and some other examples, but Of course, there isn't a guarantee as to what and when this may become an act. And just briefly about the government's response to the consultation and follow sort of a follow-up on the white paper. The government has retained the same approach. It has tasked regulators to publish their strategic approach to AI by the end of April this year. The ICO has already updated guidance on data protection. The Consumer Markets Authority review of foundation models. The ICO is also consulting on the data protection and generative AI. Other regulators have published to an extent their approach, but all of them should be publishing that by the end of April, as I've said. In January, the AI Safety Institute was introduced. There are various packages to boost innovation and research in AI as a result of this response and the government's efforts. So to conclude, arguably, this is an inadequate, insufficient model that lacks in coverage, that lacks in capability and other issues. So it's quite late falling behind. It's behind Europe clearly. The UK government doesn't think that understanding of the risk has matured enough to introduce a proper statutory protections. There is emphasis on highly capable general purpose AI systems, and there are some priorities set out there, including key issues such as electoral interference, discrimination, IP, biosecurity, and AI alignment in this approach. And the government has this ambition plan to lead international conversations on AI governance, which again I find quite interesting and perhaps ironic, with the AI safety summits and the following ones in the Korea and France. So I think I'll stop there. Just have a photo of our book that will be launched shortly, but I hope that was a useful, really just a brief overview with the time that I had and some of the key messages that I wanted to share with you. So thank you.
Indeed, thank you so much, Edina, for bringing in also the UK perspective and enriching our discussion in comparative terms. Without further ado, I'll immediately hand over to Lilian, who will be zooming in on the EU AI Act. Lilian, the floor is yours, and I see you're sharing the screen. Perfect.
Can you see my presentation?
We can see your presentation, yes.
Okay.
I suggest you don't share it, but do exactly what Edina was doing, so just moving.
Here?
Perfect. Exactly, so I see.
Okay, that's okay.
Slide 2.
Okay, it's good that I have not to comment on what Edina has said, because I totally agree with her conclusion. That's why it's needless to say anything. Let's start by saying that Habemus, not Papa, but Habemus Artificial Intelligence Act, since yesterday, actually, the law needs also to be formally endorsed by the Council. It's not yet published. It's not yet finished. And as we said before we started, there are still some issues to be clarified during this final lawyer linguistic check. And it is expected to finally adopt it before the end of the legislative period, before the elections for the European Parliament. Let me start by saying something very general, by saying that the debate on ethical guidelines and the white paper presented in 2021 for a trustworthy AI, which was the main goal actually of the EU, had identified the challenges to fundamental rights and the rule of law. And the idea in Europe, the idea in the European Union, was that all this situation with codes and soft law and guidelines instead of legislation, of binding legislation, cannot replace the law for various reasons, too vague, too generic, and mainly they lack what we say democratic legitimacy and the binding nature and the possibility to be implemented. The aim and the ambition, let's say, of the EU was to introduce the first binding worldwide horizontal regulation on AI, and in this way to set a common framework for the use and supply of these systems in the European Union. Actually, the AI Act was not an end in its AI was not an end perceived as an end in itself. It was perceived as a tool. And the main, let's say, ideological approach was that it has to be and remain human-centric so that people can trust the technology, that this technology can be used in a way that is safe and compliant with the law. This idea of safety and certainty, legal certainty, was also very central in the EU approach, because the idea was that safety and legal certainty are key parameters to facilitate investment and innovation. This is also a difference in relation to the UK approach, I must say. And the idea was that these regulatory frameworks, of course, should not be shaped in such a way to impose unjustified barriers to prevent European actors to be successful in the digital age. I'm quoting what is said by the European Parliament. The AI Act was designed as a comprehensive, binding law applicable to private and public sector. This is also, I would like to emphasize this, because nowadays we are discussing also the AI Convention in the Council of Europe. And there's a strong lobby from some countries that want to participate, that the private sector should remain outside the scope of AI convention. And it's important that the AI Act is applicable both to the private and the public sector. It's a horizontal legislative instrument, which is also a difference in relation to the UK. This horizontal nature of the legislation. It's complementary, which is also a positive and a negative, actually, thing to cross-reg sectoral EU legislation. It's complementary to sectoral safety legislation. And it's also complementary to GDPR, for example. This may lead to some inconsistencies in the application of the law, I'm afraid. You are already familiar with the idea of an AI system. Just let me present just very briefly here the definition of an AI system. You can read it. I would like to say that the key elements are the words infers and the word autonomy, which differentiate an AI system from any other software where the output is already predetermined. The idea of autonomy was a central idea during the negotiation. It follows more or less the OECD definition, and I would like also to say that this definition is intentionally broad, very broad, perhaps too vague, exactly to ensure that this legislation will be technology neutral, technology independent, and future-proof. If it will be, I'm not very sure, but let's see. The idea was this classification. You have already mentioned it. The classification that means different requirements and obligations tailored exactly on a risk-based approach. What is also interesting is that the levels of risks are not based on the technological method, but on the potential impact on fundamental rights. And it is also based on the intended purpose of the AI system. This is the main factor, and we have here a very nice and very well-known picture about this kind of classification. There are, as already said, 4 levels of risks: unacceptable, that means banned risks, uses of AI, including social scoring, untargeted scrapping of internet to create facial recognition databases, read Clearview case, which is already very known in Europe. High risks, that means systems that can potentially create an adverse impact on people's health, safety, or their fundamental rights. Transparency risks, like chatbots, which in this case, the main goal is that people should be aware that they interact with a non-human machine, with a non-human actor, let's say, and minimal risks. This we have here unacceptable risks and high risks, and don't have the time to discuss on this. What I would like say is also that the providers and the deployers of high-risk systems have to comply with many requirements. I think perhaps too many requirements. It will be difficult. It's not only the risk assessment, but other requirements concerning login, transparency, accurate human oversight, which also will be very challenging. Which is very interesting is that that was an intervention actually of the European Parliament and also of many professors, etc. Now it is obligatory to conduct a kind of impact assessment. This impact assessment is not the data protection impact assessment that we perform in the EU since the application of the GDPR. There is a lot in common with the GDPR data protection impact assessment, at least as the European Data Protection Board perceives this kind of assessment, meaning that it has also to assess not only the impact on data protection, but also the impact on fundamental rights. And this is also what is needed in the case of impact assessment, fundamental rights impact assessment introduced in the AI Act. This will be, and I think that it will be difficult to conduct such an assessment because there is a lack of methodology. And subject to this obligation are both the public sector and private deployers that will use these high-risk systems. And let's see how it will be performed. Of course, there are some criticisms concerning this risk-based approach expressed both at the very beginning of the discussion, but still there are some concerns that I must say I share also, because it's difficult to identify which is high risk and less risk. Perhaps at the very beginning, a system may be assessed as a low risk, and then based on the further use, yes, I'm finishing, we can use it as we can identify as a high risk. A very heavy, let's say, governance structure with a lot of EU tools and organizations, SENS, NLEC advisory forum, AI office, and this will be heavy. This will be heavy and very complicated. It's layered, it's multi-layered, but very complex. And of course, the member states have to identify, have to appoint a national authority. Let me finish by saying that it's important that now there is a right to lodge a complaint with a national authority, which was not at the very beginning in place. And, sorry. The penalties are draconian, are higher than the case of GDPR. They may up to 35 million or 7% of the total worldwide annual turnover. That means the idea of binding legislation is really important. And what is also very important, and it has to do also with the relation to other countries, is the extraterritorial scope of this legislation. That means it will apply also to providers in third countries who place services with AI systems in the EU, as well to providers whose AI systems produce outputs which will be used in the EU. That means that like in the case of GDPR, in this case, the European Union legislation is part of a legislation that tends to aims at making EU a leader in AI legislation, at least, and governing us by example and provoking this Brussels effect also in the case of AI legislation. I'm finishing. I don't like to disturb you anymore, just by saying and by citing the words of Dragos Tudorache, who was the co-rapporteur at the European Union, European Parliament, who has said that it's not the end of the journey. It's just a point for a new model of governance built around technology. And I think this is very important because we have to reflect on this. Thank you for your patience.
Thank you so much, Lilian, for this very comprehensive introduction to the AI Act, its feature, including the extraterritorial element of it, which I think is very important, the famous Brussels effect, of which Professor Anu Bradford speaks about. We might come back to this in the Q&A, but before doing so, let me hand over to my colleague and friend, Edoardo Celeste, who is also, I should say, the chair of the Erasmus Mundus Master in Law, Data, and Artificial Intelligence that DCU is leading, Emildai, and I think we have many of our students also in this call as well. Edoardo, the floor is yours.
Thank you so much, Federico, for the introduction, and thanks also to all the previous speakers. Mine will not be an intervention. I'm only here actually to conclude this section by launching actually the final output of a project of ours that started in 2020. So it's the book that actually Federico is kindly showing. So this is an edited collection entitled Data Protection and Digital Sovereignty Post-Brexit, that I co-edited together with my colleague Edina Harbinja, who is here in the panel, but also Roshin Costello from Trinity College Dublin and Napoleon Xantoulis from the University of Southampton. I would like actually to tell you a couple of words about this project that actually started in 2020, was funded by the Irish Research Council together with the UK Economic and Social Research Council. The name of the project was a Cross-Border Data Protection Network, and the four of us actually wanted to understand what the implication from a data protection perspective would have been in the post-Brexit context. So, especially in light of the fact that the UK played such a vital role in shaping EU data protection law, we were surprised by the first moves announced by the UK government that were subsequently also confirmed, as Edina has shown actually in her presentation, very pro-innovation, pro-business, against the so-called like European paperwork. So we wanted to understand what the consequences of these political announcements would have been from a legal perspective. So most of the pieces of legislation that you have heard that were mentioned in the previous presentation, the Data Protection and Digital Information Bill, at least in its first version, the one that was proposed in 2022, 2023, and then was reintroduced actually in the Parliament this year in 2020, last year in 2023, I mean in the current legislative session, but also the implications related to the AI regulation in the UK were analyzed in this book. In particularly, we focused on the intersection between the UK legislation and the EU legislation. And I think that the last few slides that Professor Mitrou presented were really connected with the core topic of the book. So why did we decide actually to focus on digital sovereignty as well? Because we thought essentially that there might have been some potential collisions between these pro-innovation and pro-business moves announced by the UK with the sort of like paternalistic pro-fundamental rights approach of the EU. So we studied actually these potential contradictions, areas of conflict, bearing in mind that the UK, despite the fact that it is now no longer part of the European Union, is still somehow de facto linked to the European Union galaxy, not only from an economic, commercial point of view, but also, as Lilian stressed at the very end of her presentation, from a legal perspective, for two essential reasons. One, because of the extraterritorial scope of application of most of the digital pieces of legislation in the EU field, so the GDPR first, and now we have seen also in relation to the AI Act, but also because in the data protection framework there is this mechanism of the data adequacy determinations. So the UK has been deemed as providing an adequate level of data protection in 2021, and this decision, which is a unilateral decision from the European Commission, of course, might be subject to revision in the future should the UK depart excessively, not only strictly speaking in the data protection field, but also by sort of like modifying excessively sort of like the direction taken by the European Union in fields such as artificial intelligence regulation, but also in the book, for example, we explored the field of online safety. So just to conclude, we are witnessing really new attempts of regulating phenomena that transcend national and regional boundaries, where all actors are called actually to give their contribution, and we're really thankful that in this panel we can see represented not only academics but also practitioners, because what we actually tried to do also in our cross-border data protection network project was to involve as much as possible also all individuals who are actively working in the field of practice, in sort of like public authorities and institutions in the UK and Ireland, but more broadly in Europe. And with that, I would like to share with you the link to the book. The book, of course, is available also in sort of like in its own individual sort of like chapters on the various institutional repositories of our own institutions. So if you go on, for example, in the case of DCU, it's DORAS, you will find the chapters that Federico and I have written, but I'm sure that our colleagues Edina and Lilian will also be happy to share maybe like on social media and after this workshop with you the online version of their own contributions. This is of course only a first step of this project, because as Lilian said, this was sort of like only sort of like the gate to that will open to another world of research, and we hope to continue this conversation with you in the near future. And then now I will be very happy to open the floor for Q&As. If you have any questions to any of the panelists, please write your question in the chat or raise your hand and we will give you the floor. Thank you so much.
I see that Victor Lopez has sent a question in chat, and maybe Ivanka also raised her hand. So perhaps we might begin with you, Ivanka.
Thank you very much. My name is Ivanka Antova, and I'm a Policy and Research Officer in the Northern Ireland Human Rights Commission. We ordered your book as soon as we saw it. It's currently in the office because several colleagues want to read it, so we're sharing at the moment. Thank you very much for a very interesting workshop. Data protection is one of the areas that the Human Rights Commission is keeping a watchful eye on in relation to, perhaps some of you are familiar with the specific situation of Northern Ireland post-Brexit and the Article 2 commitment to no diminution of rights. So my question is targeted as such to all of the speakers. I wanted to ask for your opinions, maybe insights into possible areas of divergence. Edoardo, you highlighted online safety. The Commission published a submission where we think the Data Protection and Digital Information Bill gives grounds for concerns for divergences around the use of automated decision-making and transfer of data to third countries. I would love to scout for any other examples that you might have on divergence. And also, if I may abuse the time I've been given to ask a question, you all mentioned lots of different legislations, both at EU level and UK level. I wanted to ask again for your insight into how we are meant to read all of these together. For example, at the UK level, we have the Data Protection Bill, we have the Online Safety Act, we will have an AI bill coming up. Same at the EU level. I wanted to explore some more on the overlap or interplay between GDPR, the AI Act, and if possible, digital markets and services. We're just trying to map the sources of rights protections and duties that we're all meant to keep an eye on. Thank you.
Thank you so much, Ivanka. Perhaps I might also read the question from Victor Lopez. I don't know, Victor, if you are able to turn your mic on and your camera on. If not, I will read it for you. Victor is asking, do you have any criticism regarding the definition of, of artificial intelligence, or is that, oh, Victor, there you are. Do you want to step in yourself? Maybe it's better.
Sure, why not? Yeah, my question is for anyone. Like, I'm wondering if you have like any criticism regarding the current definition of the AI, and if there is any challenge, or it is what you expected, or can we kind of see like some potential challenges of that? And the second question is regarding the relationship between AI Act and the GDPR. Do you think that they are friends, foes, or something in between?
Thank you very much, Victor, for coming in. So maybe Colin, I'll ask you to go first. We're following the same order. And the first question obviously had a lot to do with Ireland and Northern Ireland. So perhaps you're a good person to start with.
I might start with Victor first and then come back to Ivanka,
Sure.
if that's okay, just because I'd read Victor's question first, actually. So the other panelists may have something to say on the definition. I know there's been quite a lot of debate around the text itself. I think the definition is as expected. It's to a certain extent, as a lot of EU laws, it's a construct of drafting by committee, so that it will have gaps. It will have, and certainly people like me will look to exploit those gaps in due course. So it's not perfect, but it's not wildly beyond what was expected. I think the relationship with the GDPR is, I think, extremely interesting. I think there's a lot of debate still to happen about this. These are not two completely aligned pieces of legislation, and one has a focus very much on protecting individuals' privacy rights and personal data, whereas another one is about ensuring that certain systems operate in a particular way. And that's fine so long as you have a system which is processing low levels of personal data, or is processing personal data in the way that everybody had understood. We've met the transparency obligations across both pieces of legislation. Where I think challenges may arise is in two fronts. One, certainly around whether the transparency that's required under GDPR translates very well to transparency or explainability is the term I prefer in relation to the AI Act. And I think there could end up being some tension there. And then I think, which is I think is a comment which I would have really struck by in relation to Ivanka, her statement, how do we read it all together? Well, how do we enforce it all together? I think the real tension that's going to emerge is around AI enforcement versus GDPR enforcement. And I'll express a personal view, and it's not a view of the firm, but I'm kind of hopeful that AI compliance is not given to the Irish Data Protection Commission, because I don't think that's necessarily entirely appropriate. I can see a situation where it might be parked there. And I don't mean parked in a pejorative sense, but I just mean it might be put there. And I don't think that would be appropriate. I don't think that would be a good idea. So yes, I would say something in between for the moment. On the divergence piece, I think the divergence hasn't been as great so far, Ivanka, as I would have expected. Certainly on the privacy side. The AI piece I will leave to our panelists, but on the data side, I would have expected the UK to have gone further quicker than it has. But I think we're on the cusp of something happening where I think not so concerned about the rights, and I understand why you're, from your perspective, the geopolitical perspective around Northern Ireland, I get that. That would be, not saying it's less of a concern, but I think it's less of a risk. I think the greater risk is more around issues to make the GDPR a little bit more, the UK GDPR a little bit more business friendly, and the kind of knock-on effects that will come from that. And as to your final question, how do we read it all together? Having spent the last, Federico and Edoardo being in the same space, having spent the last 3 months at least trying to piece these things together, I don't know the answers to that question. I think it's very challenging. I think, you know, I'm not saying I'm a brilliant lawyer and like that, but I've been a lawyer in this space for quite some time, for nearly 20 years. And this is the most amount of legislation that I've been faced with you know, the quickest pace for some time. So I think that's going to be very, very challenging.
Thank you very much, Colin. Edina, Lilian, do you want to come in and add something to this as well?
I'll just briefly, and then I pass on to Lily. I'm sure she has. I would agree with Colin with regards to adequacy. I don't see it being substantively challenged at the moment by the DP-DIB, and I've written that more on that in the chapter. However, with the developments of the regulation, AI regulation, and other pieces of regulation and implementation of the Online Safety Act that we probably forgot to mention, but it's also one to map out. There might be some threats to adequacy in the overall assessment of the UK's protections in the legal system. So it's not just about the DP-DIB and GDPR changes. So I think I'll probably stop there and let Lilian intervene if she wishes, because yeah, we're running out of time. Thank you.
Actually, the questions are stuff for at least 5 webinars, okay? Let me say that I share the idea that it won't be a good idea to that the Data Protection Authority will become the enforcement authority for the AI Act, because there is an overlap, of course. I have written a text in 2018 by saying there was no idea about AI Act, and I said that in my opinion the GDPR was adequate in order to face also problems raised by AI Act, by the artificial intelligence. If we apply the principles and the other rights, for example, the right to explainability, there is a right to explainability. Of course, there will be, in my opinion, there will be problems of consistency by applying the two tools. And what I'm afraid of is that the AI Act is actually a product liability legislation. It's not a fundamental right legislation. And it will be difficult to combine and to apply both legislative tools in a consistent way. There is, for example, concerning the data protection impact assessment, there is a phrase in a recital saying that in case that they have already conducted the data protection impact assessment, they can do it in conjunction with the AI assessment. I am afraid of the consequences of such approaches, I must say.
Thank you, Lilian. That was a strong statement. I'll hand over to Edoardo, who maybe wants to add more on the UK and Ireland, and also collect a couple more questions that we have.
Yes, thank you so much, Federico. And I'm also conscious of the time because we promised to finish at 1 p.m. Dublin time. So I just wanted to maybe address originally Manka's question, like thanking her for actually highlighting these issues. So these were really like the core of our project. Unfortunately, I mean, the funding for that project ended, but we're looking for other other options to continue this research. Especially because, as you said, the UK, insofar as it was part of the EU, of course, it had a series of fundamental rights guarantees that now given, I mean, in light of the sort of like departure of the UK from the EU, the government, of course, has more flexibility. So what are the critical elements there? I think that we stressed a lot the sort of like pro-business and pro-trade attitude of the UK government. I think it's certainly one of the elements, the factors that is pushing towards sort of like legislation which is partially departing from the EU approach. The second element that has been mentioned, let's say in a non-serious way by Edina at the end of the presentation, was this sort of like willingness of the UK to lead the development of AI, and more broadly speaking, like technologies worldwide. So this enters in direct collision with this willingness of the EU. This is now explicit in all the EU policy documents as well. And of course, non-serious in the sense that then in the facts, of course, the UK didn't follow with their original intention. One element that has not been mentioned yet, but in the context of the cross-border data protection network project, this was a core part, is the law enforcement and national security field. So in relation to this, actually the UK, we could say that it departed from the EU approach even while it was a sort of like a member of the European Union. There have been a series of very concerning cases, especially before the European Court of Human Rights, where the UK has been sort of like condemned for failing to guarantee the protection of the right to privacy, the right to more broadly like a series of fundamental rights due to its national security, law enforcement, and quasi-mass surveillance practices. So I would say maybe like these three factors, these three areas should be monitored in the future to see if these will sort of like create some tension with the adequacy decision. Federico, we'll hand over back to you.
Yes, so maybe we could collect two more quick questions. I see Alejandro has raised his hand. So perhaps, Alejandro, you could ask your question very quickly and briefly.
Just a quick question. I think that the Artificial Intelligence Act is not over a main problem about intellectual property. I think that copyright law, international copyright law, should be changed. Then I would like to know if somebody has an opinion about if this law, this new piece of legislation, is just a patch, because there is a need to a big leap, a big change about the international regulation about copyright. And I don't know if someone has an opinion about the link between AI Act and copyright law. That's
Thanks, Alejandro. Indeed, Colin had spoken about IP before. Let me read the question from Lucas Latini, who is asking our panelists, from a practical point of view, how do you see organization complying with data subjects requests in the context of artificial intelligence that were trained with personal data? Now, perhaps I will ask all the panelists to respond either to one question or to the other or both, and we might take them in reverse order. Lilian, do you want to go first?
Yes. Actually, both the case of IP rights and the case of using the personal data for training the system in the context of machine learning, actually, it's a huge problem. We have already the debate in the US about fair use, or if we can opt out in Europe from using our work, our protected work and creations for training these systems. But let me say that this is a major issue, because the fact that the personal data will be used for training, it's not a new question, actually, because the answer is how. In an anonymized form, as synthetic data, as pseudonymized data, if they will be used as personal data, that means identifying, permitting the identification of the natural person, in this case, at least a person should be informed about this use, and will have also all the rights to react and to opt perhaps to deny that this data, if they have been collected on the basis of consent or whatever, for example. But in this case, a major issue that we face in the context of scientific research projects is that if somebody asks for the deletion of the data that have been used for training systems, perhaps we have already faced such issue because of the decision of the judgment of the Italian Data Protection Authority, the Garante, who has ordered a municipality to delete all the data, and they had ordered also the deletion of the data that have been used in the context of an EU research project, and the training was based on this data. That means you may be there without the material that we have used for 2 years in order to train a system. That will be a kind of one of the major issues that we have to face. I'm not ready to respond to the questions, how should organization respond to this? They have to reflect on.
Thank you, Lilian. Edina, do you want to add something?
No, thanks. I'll agree with Lilian, and I will have to leave soon. Sorry, teaching is coming up. So yeah, thank you. I agree with Lilian in response.
Thank you, Edina, and sorry for running late, but I guess the seminar really attracted a lot of questions. Colin, the floor back to you.
I'll be very, very, very brief, and I'll just say I agree with Lilian. I was just saying one thing. I was particularly struck by the reference she made to the AI legislation being the EU being a piece of product liability legislation, potentially. I think that's a very useful way for people to think about this and how it's not a right. It may have aspects which are rights-based, but it's quite different. And I think that's just a incredible. If you take nothing away from today and certainly from anything I've said, that's a really powerful thing, I think, and people to think about these things. Yes, really difficult to answer DSARs. It's really difficult to answer DSARs anyway. Frankly, it's very expensive and they're very messy. It's going to get exponentially more difficult with AI. And on intellectual property, that may be it may be that AI drives changes in IP, and maybe I'll leave it at that, because the IP system that we have has been in place for quite some time. And maybe it is time for a change. I'm not saying I think it is or it isn't, but maybe AI will drive that particular change. So I wouldn't be surprised if we see some reform in relation to IP over the next number of years arising from the manner in which AI operates within our society.
Thank you so much, Colin, for all your input. And let me finally give the floor to Edoardo, our colleague at DCU, who will be concluding this, also celebrating again his book. Edoardo. Thank you so much.
Thank you so much so first of all to Federico, for introducing the speakers and to officially open this workshop. I also wanted to thank really warmly all our panelists and all of you actually who attended this meeting for following our project, supporting actually this project, and we hope actually to continue working on these various issues. So please stay tuned. On behalf of the Law Research Centre, the Law and Technology Research Cluster, and the EMILDE program, we would like to thank you, and we hope to see you soon on these channels. Thank you so much. Have a good day.
Thanks all. Bye.
Bye-bye. Thank you very much.
Bye.
Thanks very much. Thank you. Bye-bye now.